Good morning. May it please the court. Max Kirk, together with Dan McClean, we're representing Matt Noel today on this licensing matter. We were before this court some time ago, November of 2017, as I recall, on a temporary application for a temporary suspension of Mr. Noel's license, emergency basis. We said at the time that there's a story to be told here, facts to be developed, and this court graciously saw fit to give us the opportunity to do that. The facts have pretty well been developed in this case at this time. We don't have a lot of dispute with the facts as found by the division, and I've tried to say in our brief where we have areas of conclusions of law rather than factual issues that they've done. But basically, the commission got it right in terms of the findings of the facts. The facts aren't that greatly in dispute. It's the conclusions we're drawing from those facts that I think are the fighting issues here in the case. The case arises out of Mr. Noel's billing issues while under contract with the State Public Defender's Office. Two broad categories of problems that developed. One is mileage issues, where it was indicated that Mr. Noel and others, I might add, under contract with the State Public Defender, did what we call duplicate mileage. I'm billing twice for mileage. I'm billing for 2 clients and 1 trip. I go to the courthouse in Macokota. I see 2 clients. I'm going to bill both clients for the full mileage, even though I've only made 1 trip. That's one issue. The other issue was the work for the State Public Defender's Office for family team meetings involved in the juvenile court process, where as the appointed attorney, Mr. Noel would go meet with the family, social workers, the county attorney, and other professionals involved in the youngster's problem, and have a meeting. They would have a meeting. And Mr. Noel said there was times when his records were crappy, or they're terrible, they were sloppy. He admitted that. There's no question about that. There was the allegation, which led to the criminal charge, was that he was falsifying those records. He would bill time for a family team meeting when he wasn't there. Mr. Noel's records didn't let him show where he was there or not. I think he testified pretty clearly before the division. There's times when
the counsel, he pled guilty to theft. Why isn't that issue preclusion?
It is not preclusion on the suspension in this case. I think if it were, Justice Waterman, then why have a hearing? Why submit it to the division? If a criminal charge results in a suspension, imposition of discipline, then the court, why have the disciplinary committee go through that?
You still need the hearing to get the recommendation on the length of the suspension, and also to issue preclusion is something the board has to plead and prove, but they say they did.
Well, I understand. We did some briefing work. I'm not going to address it right now on the issue of preclusion, but you know, I anticipated that question. Well, what are we even here for? Because he pled guilty to 2 charges. The story behind that, I think, is of importance. You know, the disciplinary matters we're dealing with, you read the cases, involve intentional, deliberate misconduct. You know, now you could argue that Mr. Noel did that. You could argue Mr. Noel didn't do that. But there was felony counts that were reduced to the misdemeanor counts. In sum total.
But when you plead guilty, you're pleading guilty that you intentionally did it. I mean, he could have tried the case and said it was accidental, there was no intent, and if he was found not guilty, it wouldn't be issue preclusion.
Sure.
But when you...
It's quite a decision to put somebody...
That's an intentional thing, and that's the choice your client made.
And I think what I'm trying to say, and I'm not getting this across very well, Mr. Noel has taken responsibility for that. He pled guilty. He's not saying anyone coerced him to do that, or he was misled, or not had good, effective counsel on that. He pled guilty. He did that. But that alone doesn't justify the imposition of 1-year suspension. I think that's what I'm trying to say.
While we're talking about the suspension, so we've had, looking, you know, cases on overbilling of the State Public Defender, Kawasa, and then I think it's Mathis is the one, and one ended up being 90 days and 160. One of them, I think Kawasa had an OWI on top of it. But in both of those cases, we had findings that there was no intent to defraud, intent to commit a theft. It seems to me that's not the area we're in now in light of the guilty plea. And there, which in effect acknowledges the elements of the crime, including that it was intentional, as Justice Wiggins was saying.
Absolutely, and to that extent, it's correct. But if you compare with the Mathis case, and Matt Noel can't determine who's charged and who's not charged. But you look at the Mathis case, the amount of money that was involved, the obvious overreaching that was involved. And if we're looking at, was that individual, did he commit conduct that would render him excessive billing? You know, bring into question his conduct to practice law in the state of Iowa? Irrespective of the criminal charge, the answer is yes, and the answer was 60 days.
All right, so Mr. Kirk, tell us Mr. Noel's story then. What do you want this discipline or this proceeding to focus on?
I want this proceeding to focus on the fact that Mr. Noel engaged in conduct with regard to the duplicate mileage that was engaged in by many, many other individuals under contract with the State Public Defender's Office. This is not an open and shut, clean deal. Sam Langholtz testified, and we've cited that in the transcript, that the administrative rules that they were using to interpret how these people should charge mileage were not clear. The rules were changed after Mr. Noel was charged. Others who had committed similar conduct were hired by the Public Defender's Office to work with the duplicate mileage issue. So that's one issue there, which I think clearly demonstrates that Mr. Noel was, call him whatever you want, sloppy, but there wasn't good administrative guidance from the rules themselves as to what to do. Number two, with regard to the state public, the family team meetings, 2 serious misdemeanors. I think it should be a sanction on that. Mr. Noel understands there should be an imposition of a penalty, but 1 year is harsh and it's arbitrary, especially when we consider the conduct. You can take the conduct of, here's a plea of guilty to this charge, and then compare it with other facts with Mathis' case. Much more aggravated in terms of the extent of the fraud perpetrated, the extent of the mistake perpetrated. And if you compare the two, I don't think the fact that there was a plea to 2 serious misdemeanor charges alone justifies that much of a more of a penalty. The purpose of the penalty is to protect the public, set an example. I don't think there's anything in a year's suspension that's going to protect the public from Matt Noel. The record shows before the commission, the division, he's improved his billing practices, he's consolidated his practices, he's not running all over eastern Iowa trying to represent clients at this point in time. He's made some significant changes in his practice, and he's made restitution. And he has been contrite about this, and so don't let my remarks about the issue preclusion, it's kind of a two-edged sword there. Yeah, he pled guilty to it, but there's a reason he pled guilty to it. I guess that's what I'm trying to say. There's a reason, there's a story behind that, the backstory. That's what we're trying to get out on that.
You commented that it was sloppy. I think you're trying to distinguish yourself and make it more like the cases that had a lesser recommended period of time. But sloppy doesn't quite seem like the right word. When the mileage claims that were submitted, it actually took probably more work to accomplish what he did. There was a lot of overlap. There would be more opportunities. He had to write down more information. He had to present more information on more cases instead of just one. So is sloppy the appropriate word?
Well, I think sloppy would be careless. I'm not sure quite what the right description.
And that's what I'm distinguishing. I think it's more than careless. It's an active, concerted effort, according to the record, to make there be more than there was.
But the record shows when he billed in that manner, he thought he was appropriate to do that. He thought it was appropriate. That's how he had been trained, how he had been mentored. Other members of his firm, the record shows, were found to have committed the same mileage billing practice. Same one.
Also, you mentioned that there were other attorneys. I don't think we normally go there, but didn't Mr. Langholtz's letter talk about that the amount of mileage paid for your client exceeded anyone else in the state?
He was busier than anyone else. I don't know that it exceeded Mr. Mathis. I don't know.
Well, the letter doesn't talk about being busy. It talks about mileage, and you've already conceded that he overbilled billed.
The number of clients, the number of the practice that he was involved in resulted in the higher amount. And Mr. Langhold said it was the highest amount, and he's a magistrate, so that's why they charged Matt Noel with the crime. Charged him with the crime. I would just ask the court, when you look at the severity of the sentence, I think it does bear comparison to the Mathis case and some of these other cases, to look at the gravamen of what was actually done and the penalty that was meted out. I'm going to yield to Mr. Harms, and Mr. McClean will do the summation. Thank you.
Mr. Kirk, thank you as well. Mr. Harms?
Chief Justice Cady, Justices, may it please the Court, Wendell Harms representing the Board. I'd like to turn first to the issue of Mr. Noel's knowing violation of the fees rule. The evidence in this record convincingly demonstrates that Mr. Noel knowingly collected unreasonable fees and mileage expenses in his billings to the State Public Defender. Contrary to his argument that the Board presented no evidence on which to conclude that he collected unreasonable fees and expenses, the Board presented ample evidence in support of its claim. Mr. Noel, first of all, Mr. Noel pleaded guilty to theft, crime of dishonesty, theft in relation to his fee billings for family team meetings. In his testimony before the Commission about billing mileage to the State Public Defender, he acknowledged that he was aware that he had not made the number of trips for which he billed. That's not haphazard, that's intentional. I didn't make the trip, but I'm putting it down. Now, at some point you have to say, where does honesty come into this? The contract wasn't quite specific enough. The regulation wasn't quite specific enough. Mr. Noel said he didn't read the regulation, so that's, whether it's specific or not so important. But really,
I mean, I guess I'll give you my take. I don't think you need a regulation to tell you if you make the same trip for two different clients, you can't bill both of them the mileage. I mean, I think that was something. But having said all that, as I read your brief, Mr. Harms, you do what sometimes the board does. You just say significant suspension or whatever. What is the board's position on what would be the appropriate suspension, and how do you line that up with the precedents?
all right. Well, you mentioned the Mathis case. I handled the Mathis case as well. That was the court came out with a 60-day suspension. The evidence in that case really showed that Mr. Mathis was, I don't like to use this word necessarily, but the one that comes to mind is he was really clueless about what he was about. He had his secretary doing these billings and so forth. And he seemed to be very disconnected. His supervision of her was totally inadequate, and this was the result. In that case, we also had the memo from Mr. Sand, the Assistant Attorney General who was handling these cases, who reported that he found no intent, no criminal prosecution could be proven with regard to Mr. Mathis. I think the other case then that you want to consider, and it's a bit older, from a different era, 2004, still under the old DRs as we remember them, Miss Cynthia Toffelmeyer. I think Mr. Noel fits closer to Miss Toffelmeyer than to Mr. Mathis. Miss Toffelmeyer, you may recall, was employed part-time, well, no, she was employed full-time, I believe, by the Workforce Development, but they had a procedure by which she could also do State Public Defender work. She cheated the Workforce Development people, and she cheated the State Public Defender. Now, she was not criminally prosecuted, but she was suspended for 2 years. She knowingly was misusing sick leave. She was also charged, or the evidence established overbilling, excessive billing, total time, more than 24 hours a day, that type of thing, plus half an hour for a short letter, you know, same letter 4 times is 2 hours worth of time. So my view would be that the sanction, it should exceed the 60 days that Mr. Mathis received, and it should be more in line with the suspension that Ms. Toffelmeyer received of 2 years. Now, the commission came in with 1 year. I think that's certainly an acceptable time period. I would say that the board's view would be that this should be a suspension for which Mr. Noel should have to seek readmission, or reinstatement, if you will, rather than automatic. Initially, Mr. Noel argued for 90 days. Mathis comes out, he argues for 60 days. Closer to the 1 year is where I see it. We've had this talk about haphazard billing. Keep in mind that the board's exhibits here, 18 and 18A, which took a while to put together, showed that Mr. Mathis' multiple billings exceeded 35,200 miles. This is in eastern Iowa. You could go around the equator more than once for that number of miles. Actually, you could go 1.4 times. I don't know where that'd leave you. India, maybe. That stands out.
And I understand those facts, but and I'm not gonna try and defend things, that isn't my role, but I think, would you agree, in putting all this in perspective, the Public Defender's Office pays well below the IRS mileage rate, correct? It pays less than the IRS really thinks it costs you to operate a vehicle, right?
They were paying 35 cents a mile. I don't know what they're paying today, but at the relevant time, it was 35 cents a mile. That is below the internal revenue rate.
In my view, it would be a challenge to make a living if all you did were contract appointments for the Public Defender's Office. I'm not defending what happened, but I also think we shouldn't dramatize it too much. Do you agree?
Well, I think the facts should just speak for themselves. Mr. Noel abused the billing system with regard to mileage. He also abused it with regard to fees, but to a much lesser extent. I think the court needs to be careful to say, well, if you're underpaid, you can cheat, or you should be inclined to cheat, because how else are you going to make a living?
I'm not saying that. Thank you.
That's, all right.
Counsel, what relevance is the fact that he's was a magistrate to the sanction? Should they be held to a higher standard, even though this disciplinary proceeding doesn't arise out of his duties as a magistrate?
It certainly, then we get into this business about public perception of lawyers, or public perception of government, I suppose, at another level. And you have the idea that not only a lawyer, but also a judge is then charged criminally for theft. That packs a punch, I think, with the public. How do you say, well, boy, I have a dispute. I'm going to hire a lawyer, and I'm going to stand in front of a judge or a jury, and I'm going to feel real confident about the integrity of all the players here that we have, when you've just had your cup of coffee and you've read that story in the Dubuque Herald. It can't help but make a difference. So yes, I think that is a distinction that that Mr. Langholz didn't miss in reporting Mr. Noel's conduct to us.
Should we minimize the significance of the guilty plea for theft because it can be viewed as a rational decision given the potential prison time he might have had he been convicted of a felony? Or is that an effort to sort of have your cake and eat it too?
You know, people charged with crimes have to make many decisions as they go along. Number one, what counsel do you hire, or do you have appointed counsel? What type of discovery do you do? Do you hire experts and so forth? And then at the end of the day, or not quite the end of the day, but as you're getting toward the end of the week, you have to make a decision. Here's the state's offer. Are we taking it or we're not? I've got to get ready for trial, or I don't have to get ready for trial. I don't think it's a decision he made. It's a decision he has to live with. It's the decision that we face. But at the end of the day, it's still a crime of dishonesty. It's not a felony. He avoided that, and it was a plea deal. Plea deals are made every day. I participated in them. You as well, probably. So I don't think it's a minimization. It's a decision you have to make, and that was one he made. I think I'm out of time. Thank you.
Mr. Harms, thank you as well. Mr. McClean.
Dan McClean for Matt Noel. Matt sitting behind the bar. He was here in November as well. I'd like to address a couple of the issues that Mr. Harms raised. First, I think today is about tomorrow, not about what happened in the past. Matt Noel took responsibility for the family team meetings, an allegation that didn't occur until the auditor's report came out in September of 14. He was first contacted by the state public defender in December of 2013, worked with them through letters, offered to reimburse them the mileage, checked with his office, who had also billed in the same way. An affidavit from Chris Uppy said that's what the state public defender told us to do. So I think the limit here is on the family team meetings. The family team meetings, again, if you read the auditor's report, there are things that the state public defender wasn't doing very well at the time either, and those were asked to be corrected, and they, I guess, have done it since then. But when Matt fills out the application for the fee, there's a little box. You know you get paid for family team meetings. So if he's meeting with the family, he puts down family team meetings. Well, 5 years later or whatever it is, when we get all this notice, we can't track down anybody. We can't show that we met with the family. What the application actually shows is we couldn't prove that they had those meetings. That's why Matt took his responsibility and pled guilty.
Wasn't there evidence that other entities keep track of to indicate that he did not show because other people could prove that they were there at the family team meetings? At family team meetings, aren't there systems in place by different entities, whether it be the Department of Human Services, family providers, whoever it may be, but there is a pretty stringent system of kind of like a check-in sheet, and wasn't there evidence presented that everyone went back in time and could verify people that were there, but nobody could verify your client was there?
I would say that if you want to classify something as haphazard, it would be the sign-in sheets at DHS family team meetings.
And would I be correct, family team meetings, if we're going to focus on that and not the mileage, family team meetings, each client who is being represented there, whether they show up or not, that's going to be added to their bill. And in the end, attorneys' fees are to be reimbursed by these families who are going through the system. So they would be the people who would be paying these extra amounts of money, correct, in the end?
Correct, and family team meetings are the same issue that the state public defender had. The reason the mileage thing came up is they got software that billed by not only the case number, but could also bill by the day. Family team meetings, they appear, you don't bill for them until after the next dispositional hearing. If they're still on your calendar and you bill through them, they don't drop off. It's like the mileage thing. If you had 3 cases together and you went down and one finished, that would drop off. You'd have 2 more. When you go back through the bill, you're going to duplicate mile just because of the software. It's something you have to catch, and Mr. Noel was in a firm that not only didn't catch it, that's how the partners did their billing.
Would it be wrong for us to also consider, not only does it have to do about money, but if he said he went to a family meeting and he didn't, Doesn't that mean that a parent did not have representation in an effort to try and get their child back?
I think most of them were when there wasn't family team meetings, and that's what I was trying to tell you, that the misclassification in the description is what caused the confusion. And Matt was wrong for doing it that way. Mr. Noel shouldn't have done it that way, and after 5 years, we know he shouldn't have done it that way. But looking forward to the future, what should we do with Mr. Noel? I think a year or 2 year suspension is incredibly long, considering this court in the Bieber case gave a 6-month suspension for someone who assisted with bank fraud for a way larger sum of money. To justify Mr. Mathis not getting a long suspension because he was clueless, well, in Mr. Noel's situation, he was a first-year lawyer in a firm, and he was following what the other people did. I think first-year law students' billing could be termed as clueless. He ends up paying the price because he was the one that signed the documents. Mr. Noel has done nothing but try to cooperate through this whole process. December of 2013, he starts negotiation with the state public defender. He gets through with the DCI. He has to go to his old firm that he doesn't like, produce all the records. He talks to the FBI. He's met with anybody and everybody who's wanted to meet with him. Through the process, he realizes that what he did with the family team meetings was wrong. But we don't think today that it justifies a 1-year suspension. I see my time's up. Thank you.
Mr. McClean, thank you as well. Mr. Kirk, thank you again. And Mr. Harms, thank you again. The case of Board versus Noel is now then submitted, and the bailiff may adjourn.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.